The courtroom smelled like old wood and something else, something institutional, something that had soaked into the walls over decades of people walking in with hope and walking out with less of it. Marvell Dupree sat in the third row of the gallery, her hands folded in her lap, her grey cardigan buttoned all the way up, even though it was 72 degrees inside. She had worn the cardigan on purpose, not because she was cold, because she had learned, a long time ago, that the world treated you differently, depending on what it decided you looked like when you walked through its doors. And she had spent the last 40 years making herself easy to underestimate. The case being argued that morning was a civil matter, a wrongful termination dispute involving a school custodian named Gerald Obie, a man who had worked for the same school district for 19 years, before being let go 3 weeks after filing a formal complaint about unsafe working conditions. Gerald sat at the plaintiff's table with his attorney, a young woman from legal aid named Chandra, who was doing her best with what she had, which was not much. No precedent-setting firm behind her, no army of paralegals, just a manila folder, a highlighter, and the kind of conviction that comes from genuinely believing your client is owed something. Marvell watched Chandra organize her papers. She recognized the posture, the careful stillness of someone who knew they were already being counted out. The bailiff called the room to attention, and Judge Preston Whitmore entered. He was the kind of man who had been told his whole life that he was impressive. Tall, silver-haired, with the deliberate pace of someone who had never once in his life worried about wasting another person's time. He took his seat behind the bench with the slow ease of a man sitting down in his own living room. He didn't look at the gallery. He didn't look at the plaintiff's table. He opened a folder, glanced at it for approximately 4 seconds, then looked up at the defense attorney, a partner from Hollister & Kane named Douglas Pruitt, whose firm had represented the school district for 23 years. "Mr. Pruitt," Judge Whitmore said, and his voice carried the warmth of an old acquaintance. "Good to see you again." "Always a pleasure, Your Honor," Pruitt said, and the two of them shared the quiet, exclusive smile of men who understood each other perfectly. Chandra did not receive a greeting. She stood when the moment came, introduced herself for the record, stated her client's name and the nature of the complaint, and began laying out the timeline with the careful precision of someone who had rehearsed every word 3 times the night before. She cited the Occupational Safety and Health Act. She cited the district's own internal safety manual. She cited a memo, dated 6 weeks before Gerald Obie's termination, in which a supervisor had explicitly acknowledged the mold problem in the boiler room that Gerald had reported. She was 2 minutes in when Judge Whitmore stopped her. "Counselor," he said, and the word came out with a particular kind of flatness, the kind that meant I am tolerating your presence. "Let me understand what you're arguing here. You're claiming that the school district, which has been a functioning institution in this county for over 100 years, retaliated against your client because he filed a complaint about mold." "That is correct, Your Honor. The timeline. I've seen the timeline. Then Your Honor can see that the termination occurred exactly." "I can see," Judge Whitmore said, "that your client's termination occurred during a district-wide budget reduction that affected 14 positions. I can also see that your client had received 2 performance reviews in the prior 18 months that noted, and I'm quoting here, areas requiring improvement." Chandra held her ground. "Those reviews were filed by the same supervisor who received Mr. Obie's safety complaint, Your Honor. The conflict of interest is speculative." Judge Whitmore's voice hadn't risen. It didn't need to. The dismissal was built into the tone itself, calm and absolute, like a door being quietly shut. "Counselor, I've been on this bench for 16 years. I've seen a great many retaliation claims. They require more than a sequence of events that happens to look convenient for the plaintiff. We have documentation. You have a memo and a timeline. Mr. Pruitt has 19 years of district employment records, a budget reduction audit, and 2 HR reviews." He paused, letting the weight of it settle. "Are you certain you want to proceed?" In the gallery, Marvell's jaw tightened. "Just slightly." Chandra said, "We are absolutely certain, Your Honor." Judge Whitmore leaned back in his chair. Something shifted in his expression. Not quite amusement, but something adjacent to it. The tolerant condescension of a man watching someone insist on the wrong answer. "Then let's hear your first witness." Gerald Obie took the stand. He was 53 years old, a quiet man with large hands and a measured way of speaking. The kind of man who chose his words with care because he had lived long enough to know that the wrong word in the wrong room could follow you home. He described the mold. He described the smell, damp and thick, the kind that got into your lungs and sat there. He described reporting it 3 times before putting it in writing. He described the meeting with his supervisor 2 days after the written complaint, during which he was told his attitude had been a problem for some time. He described cleaning out his locker on a Tuesday in February, 19 years of work, reduced to a cardboard box, while 23-year-old teachers who had never once touched a mop kept their jobs. He was calm throughout, devastatingly calm, the kind of calm that only comes from having already grieved the thing you lost. Judge Whitmore asked exactly 2 questions during Gerald's testimony. Both were about the performance reviews. When Chandra stood for redirect, she turned to Gerald and asked him gently, "Mr. Obi, in 19 years at Carver Elementary, did you ever receive a formal disciplinary action?" "No, ma'am." "Did you ever receive a written complaint from a parent, a teacher, or an administrator?" "No, ma'am." "Did anyone, at any point before you filed the safety complaint, tell you that your performance was a concern?" "No, ma'am. First time I heard it was in that meeting. First time in 19 years. The room was quiet for a moment. In the gallery, someone shifted in their seat. A woman 2 rows behind Marvell murmured something under her breath. Judge Whitmore looked at his watch. Marvell had been watching him do that, glancing at his watch with the patient discomfort of a man at a party he hadn't wanted to attend. She had seen this particular performance before. She had seen it in other courtrooms, in other cities, in other decades. The slow, deliberate neutralization of a human being's testimony through the sheer force of inattention. The message it sent to everyone in the room: "This does not require my full presence." Chandra called her second witness, a former colleague of Gerald's who had also reported the mold and who had left the district voluntarily, but could speak to the conditions. Judge Whitmore sustained 3 of Pruitt's objections in rapid succession, 2 of them before Pruitt had finished the sentence. Then Douglas Pruitt stood for the defense's opening remarks, and Judge Whitmore settled into his chair with the relaxed attention of a man watching something he genuinely wanted to see. It went on like this for another hour. During the recess, Marvell walked to the small alcove near the water fountain and stood there, not drinking, just standing. A woman approached her, late 30s, wearing a lanyard from the county clerk's office. She looked at Marvell with the careful recognition of someone who wasn't sure if they were allowed to say what they were thinking. "You're not from here," the woman said finally. It wasn't a question. "No," Marvell said. "You here for the Obi case?" "I am." The woman glanced back toward the courtroom. "Whitmore's had this thing on his docket for 3 months. Everyone knows how it's going." She said it quietly, not with bitterness exactly, but with the flat fatigue of a fact that had stopped being surprising. He and Pruitt go back. They were in the same fraternity at State. You can look it up. Marvell nodded slowly. "I appreciate you telling me that." The woman looked at her again, at the grey cardigan, the sensible shoes, the calm expression that gave nothing away. "Are you a reporter?" "No," Marvell said. "Lawyer?" A pause. "Not exactly." The woman waited, but Marvell didn't add anything. After a moment, the woman nodded, pulled her lanyard straight, and walked back down the hall. Marvell stood at the water fountain for a little while longer. She was thinking about Gerald Obi's hands, the way he'd held them on the stand, flat on his thighs, perfectly still, as though keeping them still required some effort. She knew that effort. She knew what it cost. She thought about something that had happened 31 years ago, in a courtroom not so different from this one. She'd been 26 years old, just out of law school, sitting second chair in a case she believed in completely. The judge that day had never once looked at her directly. He'd addressed every question to the senior attorney beside her, an older white man named Farrow, who kept quietly redirecting the questions back to Marvell, because the answers were hers and he knew it. At the end of that day, the judge had complimented Farrow's argument. Farrow had said, very distinctly, "Thank you, Your Honor." "That argument was prepared by my colleague, Miss Dupree," the judge had said, "Of course," and closed his folder and left the room. She had won that case. She had won a great many cases after it. She finished her water and went back inside. After recess, Chandra moved to introduce a secondary document, a safety inspection report, from an independent contractor, filed 8 months before Gerald's termination, which corroborated his account of the boiler room conditions. It was the strongest piece of evidence she had. The kind of document that in a fair proceeding would anchor the entire argument. Pruitt objected on foundation grounds. Judge Whitmore looked at Chandra. "Can you establish the foundation, Counselor?" "Yes, Your Honor. The inspection was commissioned by, because if you can't establish it properly, I'm not going to admit it." "I understand, Your Honor." The inspection was commissioned by the district's own facilities director in March of last. Was the facilities director present today? "No, Your Honor, but we have the signed report, which bears the contractor's certification and the district's." "That's hearsay if the inspector isn't here to be cross-examined." Chandra paused. Marvell could see the pause from where she sat. It was the pause of someone reassessing rapidly, measuring the distance between where they are and where they need to be. "Your Honor, under Federal Rule 803, business records that are made in the regular course of—" "I know what Rule 803 says." Judge Whitmore's tone dropped a degree. Not angry. Something worse than angry. Bored. "I've been reading federal rules since before you graduated high school, Counselor. Are you going to tell me how to do my job?" The room shifted. One of the people in the gallery exhaled audibly. Chandra's voice was steady. "I would never presume to tell Your Honor how to do your job. I'm simply citing the rule I believe applies." "Documents excluded." He said it without looking up. "Move on." And there it was. The thing Marvell had been watching build since the morning session. Not a dramatic moment. Not a scene. Just a quiet, efficient erasure. The kind that left no fingerprints. The kind that was perfectly legal. The kind that 19-year men lost everything to. Gerald Obie stared at the table in front of him. He didn't react visibly. He'd already learned not to. Marvell sat with her hands in her lap and breathed evenly and waited. Chandra attempted twice more to recover. She was good. Genuinely good. The kind of attorney who would be formidable in 10 years if the system didn't break her first. But every path she tried met a wall, and the walls all had the same texture, patient, reasonable sounding, entirely airtight. When the afternoon session wound toward its close, Judge Whitmore began the process of wrapping up the day's proceedings. He made a few summary remarks, the kind that weren't technically prejudicial, but that everyone in the room understood as a verdict being written in real time. He said things like the evidence as presented and the legal threshold for retaliation requires more than, and sympathetic as the plaintiff's situation may be. "Your Honor." The voice came from the gallery. Judge Whitmore looked up. His expression cycled through surprise, irritation and condescension in about 2 seconds. Gallery members did not speak in his courtroom. "Excuse me." Marvell Dupree had stood up. She was not tall. She was 61 years old and wearing a grey cardigan and sensible shoes and glasses she'd had for 4 years. She looked, as she always had, like someone whose presence the world could afford to overlook. "I apologize for the interruption, Your Honor. I wonder if I might have a brief word." "Ma'am, this is not a public forum. If you have business with this court, you'll need to." "I do have business with this court," Marvell said. Her voice was even. It had the quality of something that had been tempered by use, by argument, by 31 years of knowing exactly what she was saying and why. "My name is Marvell Dupree. I'm a sitting justice of the 7th Circuit Court of Appeals. I've been observing this proceeding in my personal capacity, but I think what I've observed today warrants a conversation." The silence that followed was a particular kind of silence. Not the absence of sound, exactly. More like the sound of an entire room recalibrating. Judge Whitmore did not move for a moment. Then he sat forward slowly, and the easy confidence that had occupied his posture all day went somewhere else. I wasn't informed." "No," Marvell said pleasantly. "You weren't." Pruitt had turned in his chair. He was staring at her with the expression of a man doing arithmetic he didn't like the answer to. Gerald Obie had turned too. He looked at the woman in the grey cardigan, and something moved across his face. Not triumph, not relief exactly, but something older than both of those things. The look of a person who had stopped expecting to be seen and is still adjusting to the fact of being seen. Marvell walked down the aisle of the gallery toward the bar, unhurried. She set a small leather case on the railing and opened it, removing a document. She placed it on the edge of the plaintiff's table in front of Chandra and said, quietly enough that only the attorney could hear, "The inspection report is admissible under 803(6). This is the case citation. You may want it." Then she turned to the bench. "Your Honor," she said, "I've been on the appellate bench for 11 years. Before that, I spent 17 years in federal practice. I've reviewed roughly 4,000 cases in my career, and I've written opinions on evidentiary procedure that are currently cited in 12 jurisdictions." She paused. "I watched you exclude a document this afternoon that was admissible on its face. I watched you sustain objections before they were fully articulated. And I watched you communicate, through tone, through timing, and through the particular way you looked at your watch, that the outcome of this proceeding was not something you considered to be in genuine question." The room was so quiet that someone's chair creaking in the back sounded like a gunshot. "I want to be clear that I'm not here in any official capacity today. I cannot compel anything, but I am a mandatory reporter under the Judicial Conduct and Disability Act, and what I observed today will be reflected in a report to the Seventh Circuit's Chief Judge by the end of this week." She let that sit for exactly as long as it needed to sit. "I'd encourage Your Honor to consider whether the record of today's proceedings, as it currently stands, is the record you want reviewed." Judge Whitmore opened his mouth, closed it. His face had gone through several colors in the last 30 seconds. "I'd also note," Marvell added, with the same unhurried evenness, "that the Obi matter has a procedural path forward that Your Honor has not yet explored, specifically a continuance to allow the plaintiff to properly lay foundation for the excluded document. That would be well within Your Honor's discretion." Another pause. "It would also be the right thing to do." She gathered her case. She nodded once at Chandra, who was sitting very still with the expression of someone trying to process several things at the same time. She nodded once at Gerald Obi, who nodded back. Then she walked toward the exit of the courtroom, unhurried, the same way she had walked in. At the door, she stopped, not because she'd forgotten something, not because she wanted to look back for effect. She stopped because she heard behind her the sound of Judge Whitmore clearing his throat, and then his voice, measured and careful in a way it had not been all day. "The court will grant a continuance to allow proper foundation for the excluded. Will reconvene in 2 weeks." Marvell pushed open the door and walked into the hallway. The woman with the county clerk lanyard was still there, refilling her water cup at the fountain. She looked up when Marvell came out, and her eyes went to the leather case, and then to Marvell's face. "Seventh Circuit?" she said. Marvell smiled. It was a small smile, not triumphant, something quieter. 11 years. The woman looked at her for a long moment, then she let out a breath that sounded like it had been held for some time. "He still might tank it on the next date," she said. "Whitmore." "He might," Marvell agreed. "But now there's a record, and he knows there's a record. That changes the math." She buttoned the top button of her cardigan, because the hallway was cooler than the courtroom, and started toward the exit. The woman at the fountain watched her go. "Why the cardigan?" she called after her. It came out sounding like the real question underneath it. "Why let them underestimate you?" Marvell paused mid-step. She considered the question the way she considered most things, genuinely, without hurry. "Because I spent a long time being angry about what it cost me," she said finally, without turning around. "And then I figured out it was actually useful." She resumed walking. "Let them think they know what they're looking at, and then do your job." She walked out through the glass doors and into the afternoon, and behind her the courthouse went on doing what courthouses do, full of people trying to convince someone with power that they deserved to be treated as though they were worth the trouble. Gerald Obi had 19 years. He had a memo. He had a young attorney who stayed up too late and believed too much and kept going anyway. And he had 2 weeks now, instead of a door closed quietly in his face. It wasn't everything. It wasn't justice handed down clean and complete, the way people in movies got it. It was a crack in the wall, small, hard-won, the kind of thing that required someone with the right credentials to walk into the right room and say the right words in a tone that left no room for dismissal. That was the truth of it, and Marvell Dupree had known the truth of it for 31 years, that sometimes the system needed to be reminded it was being watched, by the right eyes, in the right room, with the right history behind them. She didn't love that that was still true, but she was very, very good at being that reminder.